Call the roll to order. Senator Zaslow.
Here.
Senator Norman.
Here.
Senator Lucas. Senator Obenstein.
Here.
Senator McDougall. Senator Stewart. Senator Stanley. Senator Chafin.
He's here.
Senator Deeb. Senator Peterson. Senator Serval.
Here.
Jesus, you're ugly looking.
Senator Boysko.
Here.
Senator Morrissey.
Here.
Senator Edwards.
Here. Okay. How many here?
8.
8. Okay. Well, that's a quorum. Okay. Thank you all for being here. I called the meeting in order to hear from some attorneys and Colonel Pike and the Chief Operations Officer for Virginia Cares, W. Anthony West. So let me introduce Amy Ashworth. Where are you? There you are. Okay. Amy is the Commonwealth's Attorney for Prince William County and the cities of Manassas and Manassas Park. She was elected Commonwealth's Attorney in 2019. Prior to that, she practiced law in Prince William County for 23 years and has spent 19 years as a prosecutor. So Amy, welcome. Glad you're here. Thanks so much. Look forward to hearing you.
All right. Well, Shannon and I had spoken earlier. I think Shannon wanted to go first.
Oh, okay. You want to switch? I'm sorry. Somebody wrote down Amy's going first. Want to switch it? That's a good. Okay, let's do it that way then. Shannon Taylor is the Commonwealth's Attorney of some county by the name after Patrick Henry. And she was first elected Commonwealth's Attorney in 2012. Began her public service career in 1996 as an assistant Commonwealth's Attorney in Richmond. And she has been a speaker to dozens of organizations on topics including criminal justice reform, gun violence, human trafficking, and mental health, and so forth. So Shannon, welcome, and look forward to hearing from you.
Yes, sir. Thank you so much. So good afternoon to all the committee members. I am Shannon Taylor, the Commonwealth Attorney for Henrico County, and I do want to thank Chairman Edwards for inviting me to speak before you. Since I was first elected in 2011, I've been instituting criminal reforms in my office, but as the pace of reform comes more quickly, it's apparent that we need your help. To make some changes, the law needs to change, and I very much appreciate this opportunity to speak to that. I know I only have a few minutes, so I'm just going to highlight a few reforms that we could use your help with. I'm happy to have a longer and more in-depth conversation with any of you, but let's jump right in. I believe that no-knock warrants ought to be extremely rare and meet a higher bar. To get a no-knock warrant, I believe we need a judge, not a magistrate, to hear the circumstances and for him or her to rule. No-knock warrants can be perilous for the occupants of a home as well as for law enforcement. And we saw this all too vividly with the Breonna Taylor case. But in my experience, these no-knock warrants are frequently needed. Let's create a policy of not having no-knock warrants except for when this higher bar is met and when a judge has heard the circumstances and made a knowledgeable determination. We need to take another look at the felony aspect of assault on law enforcement officers. Senator Serval has been doing a great job highlighting the inequities of how many times this crime has been charged. We've all heard about the policeman being hit by the onion ring and being charged with a felonious assault. One may say that such is disrespectful, but is that really a felony charge? My colleague, Amy Ashworth, is going to speak more on this, but I did want to provide you with some data that I had pulled in response to this issue. In Henrico County, since 2017, we had 177 of these charges, of which 134 were reduced in general district court and 30 were reduced in juvenile and domestic. So 164 of these felony charges reduced to misdemeanors. I know we've also been talking a lot about hate crimes in this particular climate. And one change I think that this we can do this special session is under 18.2 423.1. which states if you draw a swastika on certain buildings used for religious worship only, it's a hate crime, but not on others. We had a case in Henrico where such symbols of hate were placed on stop signs and school buildings, areas still very much in the public eye. But whether it be swastikas or Klan paraphernalia or white supremacist signs, anything that is being used to intimidate a targeted community, none of this should be permitted on any public edifice. We need to show folks here that we're serious as a society and as a Commonwealth about not tolerating hate. We need to show that the Virginians, all Virginians, that we will keep them safe and that bigotry and hatred will not be allowed to live in the public sphere. I've been doing criminal work for almost 25 years, and I've worked with police every day. And there are a lot of good officers, a lot of good investigators out there. There are police truly dedicated to their community and their neighborhoods. However, the privilege and responsibility to carry a gun and a badge is immense. As I've said before, other than the military, this is the only profession where society knows that the professionals are armed and unfortunately might have to use that weapon. So when an officer acts out, when one is subjected to particular discipline, whether that be regarding a finding impacting truth and veracity or a pattern of excessive force, that must not be hidden away on some private and personal disciplinary record that allows him or her to leave that job and take a new one with a clean slate. That is information that prosecutors are ethically bound to have. We are required to provide those charged with offenses with what we call exculpatory evidence. That includes any finding of one not being truthful, and that includes any finding of a pattern of behavior that would indicate an encounter between an officer and a citizen may not be lawful. The disciplinary record must follow the individual, and the rulings should be available to the prosecutor, and as we've heard from the community, the public, if that officer is found to have violated the rules. I support our law enforcement agencies to weed out the bad apples so we can appreciate the good ones. It's not fair to any locality or police chief to hire someone without knowing their record, without knowing their history. It's just a problem waiting to happen. There are more reforms, I think, that are essential, from better training on the bias and de-escalation, which I know this committee has been presented with. And in my office, I will share with you that I'm instituting a new deputy to review this police integrity action, to help the community understand what's being done and to hold certain officers accountable for those violations. And more importantly, to assure the community that there's here someone to listen to their complaints. I will work to keep them safe, even if the perpetrator is a law enforcement officer. However, I know that we have limited time. I'm happy to answer questions, but I'm first going to turn it over to my colleague, Amy Ashworth, the Commonwealth Attorney from Prince William County and the cities of Manassas.
Okay. We'll hold off questions till Amy speaks. Amy Ashworth, I mentioned that she is a Commonwealth Attorney of Prince William County, just elected in 2019. Been a practicing attorney in Prince William County for 23 years, 19 years she was a prosecutor. Amy, welcome.
Thank you. Actually, it's been 25 years since I was first barred by the Virginia State Bar now. I've been a defense attorney and a prosecutor and a guardian ad litem for abused and neglected children. I was a full-time prosecutor for 11 years, working here in Prince William County.
That's all wrong. Okay.
Yeah.
Okay. Thanks for correcting me.
Absolutely. So one of the things I would love to see us tackle in the criminal justice system is adequately funding more treatment courts. We could dramatically reduce incarceration rates if we started funding mental health courts and drug addiction courts. Mental health resources, as you know, are scarce in Virginia. Drug addiction treatment is scarce in Virginia. And those are two of the problems that we see over and over and over again in the criminal justice system. As far as, I just took office January 1. I've had to deal with a global corona pandemic and 2 periods of civil unrest, one from the 2A people who were masking up and filming themselves in front of public buildings, and now the Black Lives Matter issues. I think at the heart of a lot of the Black Lives Matter issues have to do with perceived unfairness in the criminal justice system. And 2 of the ways I think we can address that is through jury sentencing and minimum mandatory laws. Both of those systems or laws make it easier for us as prosecutors to get a conviction. And the cost of that, I think it comes at being seen as unfair, being treated unfairly by people in the criminal justice system. As many of you know, sentencing in Virginia is done by a judge after they review guidelines, which are the point systems that we use, where we give people, after they're convicted of a felony, points for their crime, the history, if there was a weapon used, injury to the victim. What we don't give are points for race or religion or sex or natural origin. So, you know, the guidelines are an attempt to create a fair sentencing across the board. When we have juries that make recommendations as to the sentence, they don't have access to the guidelines. They generally don't have experience in the criminal justice system. They don't have all of the information about the case, because one of the tenets of our criminal justice system, the rules of evidence, we limit what the jurors can hear. So they don't have all of the facts when they're making a sentencing recommendation. And as a defense attorney, as prosecutor, we all know that they tend to sentence higher than the guidelines or a judge would do. And so many defendants don't want the risk of going to jury, so they will pick a bench trial, which is easier for a prosecutor, or they'll enter into a plea and recommendation, which again is easier for the prosecutor. And minimum mandatory sentences have the same effect. When the legislature decides what the punishment should be for everybody that commits this offense, it's often higher than what might be required or the right thing to do in a case. And so that puts pressure on a defendant to work out a case. So they don't want to go to trial. And so again, you have less trials, easier convictions for prosecutors. So I realize both of these things are going to make it harder for prosecutors to get convictions, but I think we're up to the task. I support amending the assault and battery on law enforcement to give officers the discretion to charge a misdemeanor if there's no physical injury. A felony arrest does have an impact on people's lives. And many times officers will come to court and say, hey, that felony can be a misdemeanor. I'm fine with that. I think giving the police officer the discretion in the field to make that charge as a misdemeanor is appropriate to do, to trust our law enforcement on that. And I think there's also, I have two easy ways we can improve law enforcement in Prince William County. I support a statewide database for police misconduct information. Currently in Prince William County, we are doing an assessment of all of our police officers that are going to be testifying here to determine if they have any misconduct that would affect their credibility. But we're only doing that with the cooperation of the police department here in Prince William County, and luckily they've been very cooperative, but we have no way to compel access to their IA investigations. And then I also support law enforcement being required to share with prosecutors evidence in their cases immediately, giving us access to their police reports and their body cam. Especially in police-involved shootings and high-profile cases. The public is going to rightfully want a response from us as prosecutors, and in order to give them a response and make timely decisions, we have to have access to that information. So thank you, and we are available. I get that these are complicated and long issues, but we're available to provide any input that we can.
Okay, are there any questions of either Shannon or Amy?
John?
Yeah, who's that? I can't see.
Joe.
Oh, yeah, Joe Marcy, Senator Marcy.
Thank you, Mr. Chairman. I got a couple of questions of each prosecutor. Irrespective of whatever your reasons for coming forward with these progressive agenda, we're grateful. You mirror a lot of what the Senate is trying to do in the special session. Ms. Ashworth, let me ask you a couple of questions. You made a compelling case that juries sentence much harsher than judges, and that's not fair. Did you support in the last session my bill for jury trial and judge sentencing?
So my only involvement last session, so in January, was at the VACA bill reading. And there was some discussion of that bill. I don't ultimately know if it took a position or didn't
They
take a
did.
position on it.
They took a position against it, but 5 progressive Commonwealth attorneys came forward and said, that's bad. Were you one of those?
No,
Right.
I certainly, and it wasn't that I opposed it, the bill. I took office on January 1 and had to clean
I got
quite
you.
a bit out. So,
Okay. Right. One final question of Ms. Ashworth. You also talked about charging defendants with felony assault on a police officer. I think one of our senators did an op-ed piece that a defendant was charged with a felony because she tossed an onion ring at a police officer. Does your office regularly and routinely amend down to misdemeanor felony assault when you see it come across your desk?
yes. And we see it charged. It's in virtually every police rundown that I see. Any interaction where there's a use of force, generally, you're going to see an obstruction of justice charge and a felony LEO, assault on LEO. And very oftentimes they are without physical injury. And
Right.
so,
You do it regularly.
yes.
Thank you. Mr. Chairman, I got a couple of questions of Ms. Taylor.
Yeah, Senator Marcy.
Ms. Taylor, this last session, there was a bill presented by Delegate Bourne to give parity for public defender salaries commensurate with prosecutors. You spoke out against that. Have you changed your mind, and do you now agree that public defenders should get the same salaries as prosecutors?
Well, Mr. Chairman and Mr. Morris, Senator Morrissey, excuse me, when we were speaking out against that, that was coming from a position of somebody who was advocating for a public defender's office in her jurisdiction. I regret that we were behind where Ms. Ashworth was enabled to get her public defender's office, but it was kind of more complicated than that. As you well know, both you and Delegate Simon have asked the Commonwealth Attorneys Association to come up with staffing standards. And it was something where, as we were trying to work with the staffing standards calculations to respond to your inquiry, and as we were working with the Comp Board and understanding that there were certain changes that might impact the prosecutor's role, it's not that I don't agree that they should be funded, or better yet, that Henrico County would like to benefit from one. I just didn't want to go ahead and say yes when I didn't have all the data. But I do support the public defender's office. I do support actually more financial resources for the criminal justice system in general, whether it be, as Ms. Ashworth talked about, money for mental health, money for rehabilitation. But yes, we've been doing public safety on the cheap, as you remember from your days, for a very long time.
I just want to know if you will support parity for public defenders. Yes,
Well,
yes or no? You will.
Well, parity is as that definition unfolds. Yes.
Mr. Chairman, another question.
Senator Morrissey.
One of the big problems that we've seen in the last few years is prosecutors requesting cash bonds for defendants, and a lot of progressive offices are now getting away from that. The statistics show right now that in Chesterfield, Richmond, Hanover, they have reduced their jail populations dramatically. Henrico, on the other hand, has increased it. There are 1,240 people incarcerated in Henrico now, a significant percentage of them African-American, and they're there because your line prosecutor is asking for no bond. What are you going to do to reduce that jail population so as to not keep people of color incarcerated because they can't make bond?
So, Mr. Chairman, to answer Senator Morrissey's question, I regret that may be a lack of information. So the question back in 2019 was the fact that we actually had up to 1,600 people in our jail facility, which was outrageous. And we identified that these were individuals who were being held without bond predominantly for substance use disorders and probation violations. With the election of our new sheriff, Sheriff Elisa Gregory, she and my office, so her office and my office, started immediately before the pandemic working on identifying individuals who should not be in the jail, whether it be making sure that they were provided access to certain rehabilitation, whether or not they were individuals who had sentences of, I think she was even using 60 days or less, individuals who could go home and be out of that jail. And we reduced the population, I should clarify, to as low as, I believe it's 1,100, so 1,142 from 1,600. If you were to take away, and this is from a presentation that Sheriff Gregory just did the other week, if you take away the state responsible inmates that are currently being housed in Henrico Jail because of the current DOC policy not to remove inmates, we would be down to like over 800. We're talking about numbers that we have not seen since 1985 or something of that nature. So I would say that Henrico is, along with other jurisdictions. I did not make it a big press release about not going with the cash bond, but my office knows that they are not to be asking for cash bond, period, and that we are aggressively working and coming up with alternatives. We have worked on a mental health diversion to get individuals out of the jail ASAP on that. We are actually starting a program within our jail system about getting people diverted for using with our recovery partners. So we've done a really great job thus far, and all you're going to see is just better progress in Henrico County. So I'm really proud of the work that we're doing with the Sheriff's Office.
Mr. Chairman, two final questions, and they're very brief.
Senator Morrissey, two final questions.
Ms. Taylor, will your office support allowing a bill that the Senate is going to introduce to allow juries to get sentencing guidelines? Yes or no?
Well, it depends, Mr. Chairman, to answer Senator Morrissey's question. If we do away with the sentencing, jury sentencing, which may actually be the better response, then I don't think we have to worry about the sentencing guidelines. So I would just like to see how that all gets presented out.
Senator Serval. Senator Serval.
Thank you, Mr. Chairman. I had two questions about the felony assault on law enforcement officer statute for either one or both of the Commonwealths. First question was, can you all think of whether there is another felony where the same person serves as both the victim, the charging officer, the lead investigator, and the lead witness? Because I don't think there is anything else.
So, Mr. Chairman, to answer Senator Serval's question, Ms. Ashworth and I, we were just talking about that earlier today. And I think the best that we could kind of equate this to is if I went down to the magistrate's office. Now, granted, not for a felony, because of course, for a felony charge, you need the sign off of the Commonwealth attorney.
Right.
But certainly there's nothing that keeps me from going to the magistrate's office to swear out and say, Amy Ashworth assaulted me. And so that was kind of like the best thing we could come up to, akin with what we're talking about with law enforcement.
Right. We only allow that for misdemeanors and not
Correct.
for felonies. This is the one felony we allowed for. And so that's something that concerns me. But second question, for the people who on the call who aren't attorneys, who maybe don't appreciate the difference, can you all describe the different amount of effort that your office has to put in when something is charged as a felony versus a misdemeanor, and how much time that causes you all to invest in a problem, and why that additional time you have to spend is a significant thing to consider? Because a lot of times you'll hear people say, well, they all just got reduced to misdemeanors, so what's the big deal? So can you talk a little bit about that? It's like, I know in Fairfax, we have a separate docket. There's a police officer gets taken off the street for like an extra 4 hours or something. I mean, there's a lot of different things that happen when something's charged as a felony instead of as a misdemeanor.
You asking that to Shannon Taylor or to Amy Ashworth?
Either one. I don't which one of them. Either one of them.
I'll let Amy answer, and then I'll say something after that.
Amy?
Right, so a felony involves a preliminary hearing, and then it has to go to a grand jury here in Prince William County, and then it gets set for trial. All of our felony cases get reviewed and scrutinized a little bit more than many misdemeanors do. We just don't have the capacity to review all the misdemeanors. The discovery obligations are different. You know, it's just treated a lot more differently. It's a lot more work, a lot more scrutiny involved in it.
And I would just, yes, sir. Thank you, Mr. Chairman. For Senator Surville, I would just supplement Amy's position, which is also to recognize there are some misdemeanors that are just as complicated as certain felonies. And so for the offices that take on the additional responsibility of handling misdemeanors, like my office is a full service, quote unquote, office, it takes up a lot of time because you've got the body worn cameras for those jurisdictions that have that. And sometimes you can have as more hours on a misdemeanor than you might have on a felony investigation, just due to the nature of the people who respond. But I think what's more concerning specifically to your the charge of the felony assault on law enforcement, that again, we've seen the data of how many times it's reduced, is what happens when an individual appears before the magistrate, who's the first person who determines bond or no bond, you know, if someone's going to stay in jail or not stay in jail, is the fact that it is a felony with a mandatory sentence. And how many people are automatically held because of those two criteria? That to me is what is the most concerning part. And which is why I'm in favor, as well as Amy, we've talked about this too. That part of the unfair aspect being the treatment is something that we should all be very concerned about, and why this needs to be looked at again.
Thank you.
Okay. Any other questions? Senator Norman, did you have a question? Senator Norman? No? Okay.
Mr. Chair.
Yeah, Senator Deeds.
Yeah, the only point I would make to the prosecutors is I would urge them to look at the San Antonio, Texas model. There, the prosecutor's office works with the police department. The two cornerstones are the mental health court and CIT training for 100% of the officers. They claim their savings in the cost of correction to be in the millions of dollars annually. I think we can emulate that throughout Virginia.
Yeah, I agree with you 100%. CIT has been very successful in 3/4 of, I think 70% or so of the localities that have it. Not every locality has it, however. Likewise with mental health courts. Any other questions? Senator Norman? Okay. Senator Sasslaw? Okay. No more questions. Well, thank you, Amy, and thank you, Shannon. We appreciate your presentation.
Yes. Thank you so much, Mr. Chairman. Thank you, all the senators.
Very important. Thank you very, very much. We move on now to Colonel Pike. Here he is. Colonel Anthony Pike was appointed Chief of the Division of Capitol Police in 2011. And he is a native of Wythe County, and began his law enforcement career in 1988 with the Virginia Department of Game and Inland Fisheries after 4 years of service in the United States Army. And I would also add that he is the son of the former United States Marshal for the Western District of Virginia. He's a friend of mine. So, Colonel Pike, welcome. Thank you very much.
Mr. Chairman and members of the committee, let me start by thanking this committee for the opportunity to speak with you today. Your task is difficult and a multifaceted one, and I applaud you for undertaking it. As part of my preparations for today, I did some quick math and figured out that the senators of this committee have a combined 218 years of service in the Virginia Senate. That reinforces that this isn't the first time you've taken on a serious topic that requires a great deal of thought and care as you chart a course for doing the right thing on behalf of the Commonwealth, our citizens, and law enforcement. During your careers at the Capitol, you've had a chance to see a protest involving more than 20,000 people, or a smaller protest that makes its way through the streets of Richmond to Capitol Square. You may be surprised to learn just how often this occurs. In the 4 years preceding this 2020, there were a total of 243 permitted and non-permitted events. In the 30 weeks so far this year, there have been an additional 47 such events. I'm proud to be able to tell you today that in those nearly 300 events in less than 5 years, Capitol Police has responded in a fashion befitting an agency charged with overseeing the seat of Virginia government. We have been progressive, we have been professional, we have been accommodating, and we've worked hard to be good communicators and even better listeners. And perhaps most crucial, we have made it a priority to de-escalate. And let's stay with that word, de-escalate. It's no secret that part of the reason we are meeting today is because of well-documented failures by law enforcement officers to de-escalate. Why does that happen? I believe large part of that answer can be traced to two core issues: accountability and training. First, on the subject of accountability, in June of this year, I was named chairman of the Virginia Law Enforcement Professional Standards Commission and was originally appointed to the commission in 2014. Division of Capitol Police achieved state accreditation in 2010, and I can assure you that reaching and maintaining this certification is an arduous process. Nonetheless, the entire certification process also instills in an agency a sense of accountability. Accreditation is comprised of 190 standards, which are divided in 4 general subject areas of operations, personnel, administration, and training. Currently, the process is voluntary, and the program is overseen by the Department of Criminal Justice Services. Accreditation is the ongoing process whereby agencies evaluate policy and procedure against established criteria and have that compliance criteria verified by independent and authoritative body every 4 years. The simple fact that is approximately only 38% of all law enforcement agencies in Virginia have either earned the state accreditation or the national accreditation, CLIA, the Commission on Accreditation for Law Enforcement Agencies. There are currently 99 law enforcement agencies that have the state accreditation certification, with an additional 26 agencies that are currently in the self-assessment phase of accreditation. On the national level in Virginia, there are 32 law enforcement agencies that hold the national accreditation standard. Having only 38% of all law enforcement agency in the Commonwealth accredited is not good enough. We must and can do better, and I strongly recommend that all law enforcement agencies be required to attain the Virginia accreditation. Because as I said, accountability and accreditation run hand in hand. If law enforcement agencies want public trust, we need the public to know law enforcement in Virginia is committed to putting in the work to gain the trust. DCJS and the Commission have the opportunity to make a meaningful changes to the current standards that can be extremely beneficial to uniformity and policy development. Accountability in our hiring process. We find law enforcement agencies who, when contacted by my investigators, will not share employment records during background investigations. We require applicants to sign a release allowing our agency to obtain copies of employment records. This waiver is available and provided to any employer that is contacted during the background process. Code of Virginia 15.2/1709 allows employer immunity from liability disclosure of information regarding former deputy sheriffs and law enforcement officers. We should never have a Virginia law enforcement agency refuse to share these critical employment records. Accountability in hiring and testing. Virginia Code 15.2/1705 Code of Virginia establishes the minimum qualifications for law enforcement. I believe this is an area that warrants further consideration for additional qualifications to be added. I recommend further improvements concerning psychological evaluation requirements and crisis management evaluation of officers. Capitol Police used 2 separate psychological evaluations during our hiring process. One test is tailored to those who have never previously been in law enforcement, and the second test is designed for those who have previously been in a sworn law enforcement position. Capitol Police have a fitness for duty medical and psychological policy, Employees may be directed to take a mandatory medical and/or psychological examination as a condition of their initial and/or continued employment with a division. Law enforcement agencies should develop and implement a program to provide the appropriate medical screening of all newly hired officers, regardless of prior certification. Also, I urge mandatory evaluation and assessment for officers involved in specific identified incidents. It is important to promote a culture of help, understanding, and non-punishment, stigma, or ostracizing culture to ensure officers are fairly and reasonably cared for. I also recommend expanding 15.2-1707, the decertification statute. This topic needs further expansion to include Brady violations. I also want to address the subject of law enforcement training. In addition to my work with the Vallepsy Commission, I'm also the chairman of the board of the Crater Criminal Justice Training Academy located in Prince George County. I find it vital that our officers not only learn proper techniques, but are kept updated on the latest available information that will help law enforcement properly serve their communities. To that point, currently, 6 VAC 20-30-30, the Administrative Code, compulsory in-service training standards require law enforcement officers to complete a total of 40 hours every 2 years to maintain their law enforcement certification. The current code only prescribes 2 hours of cultural diversity, 4 hours of legal training, and 34 hours of career development elective training for law enforcement officers. Conversely, Code Section 9.1-102, which is the powers and duties of the board and the department, DCJS, number 54 of that statute states, and this is the compulsory minimum training standards for a law enforcement officer who is charged with being a school resource officer. And in those compulsory training standards, the requirement is, number one, relevant state and federal laws. 2, school and personal liability issues. 3, security awareness in the school environment. 4, mediation and conflict resolution, including de-escalation techniques. 5, disaster and emergency response, awareness of cultural diversity and implicit bias, working with students with disabilities, mental health needs, substance abuse disorders, or past traumatic experiences, and student behavioral dynamics, including current child and adolescent development and brain research. I share this as a comparison to the previous compulsory minimum requirements for a law enforcement officer, which only have the 3 areas: legal, 2 hours cultural diversity, and the 34 hours of general elective training. I would recommend a substantial increase in hours of cultural diversity awareness training with an emphasis on ethics, anti-bias performance, personal and colleague accountability, use of force, and appropriate responses to de-escalate citizen encounters. I strongly recommend DCJS reassess these training directives. I know there's pressure on you to help heal wounds in these trying times, just as I hope you know I stand ready as always to help you any way I can. Thank you, Mr. Chairman.
Thank you, Colonel Pike, for that very informative presentation. I'd like to get a copy. Since you wrote out something, could you send a copy to everybody?
Yes, sir.
I appreciate that. Any questions? Yes, Senator Sherwood.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. And Colonel Pike, first of all, I just want to thank you for all you all do to keep us safe in the Capitol. Especially that last session was an incredibly stressful session, and I thought it went very well. And you all's professionalism and how you handle everything, I think, was a big part of that. So we appreciate that. Hey, I'm not sure if you've had a chance to read some of the policy proposals that have been proposed by the Senate Democratic Caucus, but I just want to ask you about a couple of them because I've heard that a lot of these things are already sort of in wide use. Can you just confirm for me whether or not the Capitol Police train anybody to use neck restraints or chokeholds?
No, sir. And glad for the question. We did not train in that. And matter of fact, after the unfortunate and just horrific incident in Minneapolis, I reissued on top of our current general orders through our accreditation policies, a policy memo that reinforces that only those techniques that are taught during training shall be used in the performance of the duties. And that goes back to the accountability part of my presentation.
And thank you, Mr. Chairman. I have a few other questions in that vein, really quick ones, I think.
Senator Serval.
Thank you. And I heard you talk about de-escalation, and we've drafted some language about that and similar issues. So can you enlighten us? Does the Capitol Police have any kind of training or guidance on when an officer can use deadly force or when an officer is allowed to shoot into a moving vehicle or an occupied vehicle?
Yes, sir. We have a policy that speaks to deadly force, and it's the force used to minimal force to use to control that situation. And we don't, under no circumstance, allow shooting into a vehicle, a moving vehicle. That is not allowed by policy.
Right. Mr. Chairman, additional
Yes,
question?
Senator Serval. Senator Serval.
Okay. Thank you. So just so I'm clear, then you all, I guess, train your officers to use all other means prior to using deadly force. Is that a fair statement?
Yes, sir. I've learned, and being here at the Capitol with large groups of people and the increased emotions that involve, part of what we teach our officers is to be very deliberate and slow down our law enforcement efforts and to de-escalate those situations with people. And having those conversations have been very, very important. We have in our policy, speaking of deadly force, a use of force continuum. And that speaks to, you start off your presence and then the communication piece, and you work your way up through that use of force continuum. And that's something that we emphasize in our training quite often.
Thank you, Mr. Chairman.
Senator Serval.
One final one. I'm going to ask these two together. First of all, can you just give us any thoughts you might have on creating some kind of duty to intervene? And then secondly, you talked a little bit about accreditation, and I can appreciate from your point of view, it sounds like you think accreditation instills a sense of professionality and, I guess, confidence within the force, which I understand. But and I think being licensed professionals, I know that's important to you all. But I was trying to figure out what incentive the agencies, there's over 400 law enforcement agencies around the Commonwealth, so what incentive they have to get accredited. I'm not clear, other than the bragging rights or the certificate on the wall, or I'm not clear what an agency gets out of that beyond that. So if you could answer those two things, I'd appreciate that.
Yes, sir. So what we get, and I know the employees here at Capitol Police, it's the sense of pride in knowing that we are operating under the best policies and procedures that are established out here that are the gold standard for law enforcement to operate under. It allows officers to operate with a sense of confidence. You look at Capitol Police and the type of activities that we're involved in. I know our officers, I tell our officers this way, being accredited and having strong policies is like having a good GPS unit. If you follow that, you're not going to get lost. And when you start taking shortcuts, that's when things start going afoul. And that's what's so important about the accreditation. It's not about the plaque on the wall. It's about our service and commitment to our community and those that we're charged to serve. And they can take the certificates away from here, but knowing that, we've reached this bar. And the accountability piece for me in this agency is every 4 years, independent evaluators come into this agency and spend 2 to 3 days going through every aspect of what we do, looking at and interviewing officers, speaking to them, asking them policy questions, doing ride along to make sure that we are doing the right things for the folks that we serve here daily at the seat of government.
Thank you, Mr. Chairman.
John.
Follow up.
Okay, Senator Morrissey.
First of all, Colonel Pike, I want to also thank you and your staff for your professionalism. I've been down in the General Assembly for almost a decade, not as long as a lot of people on this panel, and I've always felt safe. And the way your officers have handled huge crowds has been nothing short of stellar. We had north of 22,000 people for a gun rally. There were no incidents. And a lot of people don't know this, but the Capitol Police patrol a lot more than Capitol Square. You have a large footprint in Richmond. With that said, can you shed some insight on what has happened in Richmond with these riots, with a lot less people, a few hundred that have gotten out of control? Our city portions have been burnt, damaged, windows shattered, and I'm just wondering if you can weigh in on what you see as the problems and why this has gotten out of control.
Well,
Colonel Pike,
yes, sir.
go ahead.
Yes, sir, Mr. Chair. Senator Morrissey, we're on I've lost track of it, 50, close to 60 days of continuous protest here in the city. And I can take you back to late May when we were here at the Capitol grounds, and I was here with my staff, and we were hit with a large crowd of people at the entryway on North Drive. I had 2 officers injured. We had every type of debris thrown at us, from bricks, bats, bottles, a flare gun fired at the officers, and so forth. And to your point, we have a large area of responsibility in the city, and looking at the limited resources that I have and officers that I have, I made a conscious decision to protect the state capitol. And I will say that the state capitol is probably the only government structure left in the city of Richmond that hasn't been hit with graffiti. And that's been a deliberate, on our part, to do everything possible to protect this historic landmark here at the seat of government. We've worked with the city, Richmond Police Department, State Police has been here a lot, trying to work through the civil unrest through many days and nights. Very complicated issue, and looking forward to working more with the new police chief here on trying to bring more calm and peace to the community.
One final question, Mr. Chairman.
Yeah, Senator Morrissey.
Colonel, can you state succinctly what your office does to vet a potential hiree who is coming aboard, specifically focusing on how you determine whether they have had previous incidents in their other law enforcement employment that would make them a poor candidate for a hire? What do you do to vet?
Senator Morrissey, Mr. Chairman, thank you for the question. We have a very extensive process that we go through. Obviously, we advertise that out. Once we get the applications in, our human resource manager goes through a screening process. Those individuals are invited to take a physical agility test, which is done. Then we have a written test that we do. And then there's also, we use LESI. It's a personal history questionnaire examination that's also used by state police and other law enforcement agencies here in the Commonwealth and other states. That personal history questionnaire collects a tremendous amount of data about the candidate. And one of the things that I like about that personal history questionnaire, each time that someone applies to a law enforcement agency that uses that LESI document, they fill out a personal history questionnaire. If there are discrepancies, and we see that people will go through a process with a law enforcement agency, and there may be something that was determined to disqualify them from being hired. When they may apply with Capitol Police and they fill out this personal history questionnaire again, they will intentionally omit that information, trying to bypass and gain employment with my department. That personal history questionnaire will flag that information for us. We're able to see where it's intentionally omitted. And it goes back to this, that's an early, easy Brady violation, in my humble opinion. And therefore, that person is automatically disqualified any further in our process. So we do the personal history questionnaire, and then they come in and they do an interview with our executive staff. We have an interview session that goes through. Once that's completed, then we look at the number of applicants and positions we have available. We go through an extensive background process. We have a psychological evaluation that's done by 2 different doctors we use. Then we have a physical medical evaluation that's done. And then we finally do a offer of employment. So It takes many weeks through this process. And I will say this, and I tell my staff this, and this is my humble opinion with the type of applications we see in trying to find people. You know, I don't ever see myself being at 100% staffing because of the enormous effort that we put through in ensuring that we vet everybody that we hire on board with Capitol Police. Very difficult to find people right now for this profession.
Thank you, Colonel. Senator Boysko.
Thank you, Mr. Chairman. Colonel Pike, thank you for all you do. We really value your service and that of the Capitol Police. And one thing that you just said was discussing about you never see yourself being at 100% capacity because it is so hard to find police officers who meet your qualifications. And that's something that I've heard from other jurisdictions as well, if we are to beef up the requirements on this. But I want to make sure that I understood that you said that you believe that all law enforcement agencies should be required to get accreditation or increased training, because as of now, only 38% of the law enforcement agencies around the state are currently accredited. Is that accurate, what you said, that you believe that we should require that?
Yes, ma'am. And the reason I say that, as I've traveled around the state and I've talked to lots of chiefs and sheriffs, and you know, one of the first things they bring up is expensive. And I can tell you right now, the Virginia accreditation program, $250 is the initial fee to apply, and $100 thereafter. The National CALIA program is a lot more expensive. It's several $1,000s, but the state accreditation is extremely affordable, and it's something that financially is not a burden for law enforcement agencies. We even have very small departments. Wintergreen Police Department is a Virginia accredited agency, so they are, you know, probably less than a dozen officers, small agency, but they go through this process as well. So it requires work. It requires work at all levels of an organization. I will say that. It requires extreme accountability, internal accountability, which I think is extremely important. You know, my investigators are accountable for the evidence room, case discussions. Our communication center goes through that accreditation process. All aspects of the agency goes through it. So it puts every employee from human resource down to the patrolman through this accountability process. And it's ongoing. We don't wait till the 4-year review. We go through this accountability year round, day after day, month after month.
Okay, thank you.
Thank you.
Yeah, any other questions? Anybody have any further questions? I want to thank you again, Colonel, for keeping us safe last winter. I know you had a horrendous task. The Capitol Police, along with the state police, kept us safe, and we genuinely appreciate that very, very much.
Thank you, sir.
Thank you for being with us today, and appreciate if you send a copy of your remarks, it'd be very helpful. I'd appreciate that to everybody.
Yes, sir.
Now we have with us Anthony West. Anthony West has been the Chief Operating Officer of Virginia Cares since 2007. He is an active member of the National Association of Blacks in Criminal Justice and the Ex-Offenders United Together, along with the American Probation and Parole Association. Anthony was raised right here in Big Lick, otherwise known as Roanoke, and is using his life experience to give back to the community. Anthony West, thank you for being here. We appreciate your being here, and I look forward to hearing your comments. Thank you very much.
Thank you, Senator. I appreciate it. I want to say thank you to the committee also. I'm very humbled to be here. I would like to share some information about my agency, Virginia Cares, and talk a little bit about myself and some of my challenges as well. Virginia Cares is a statewide offender reentry program that was established in Roanoke to address the successful reentry and deinstitutionalization of returning citizens in the Commonwealth of Virginia. CARES begins as a life planning workshop with inmates at Roanoke City jails. In 1978, the first pre-release program was conducted at Body Top Correctional Unit number 25. By 1980, Total Action for Progress, a local community action agency in Roanoke, had developed the Virginia Cares program, incorporating pre- and post-release elements with behavior training and peer support. Currently, Virginia Cares provide pre-release services in 14 prisons, 9 city and county jails, and 6 regional jails. In addition, we have worked with several federal institutions here in the state of Virginia. We have contracts with 6 community action programs throughout the Commonwealth that allows our staff to provide post-release services to 26 cities and towns, 32 counties in Virginia. Since 1981, Virginia Cares has worked with more than 200,000 returning citizens. Virginia Cares has service sites in the Hampton-Newport News area, Lynchburg, Christiansburg, Abington, Fredericksburg, Danville, Covington, Clifton Forge, and Roanoke. Each of these service sites throughout the Commonwealth are staffed each with 2.5 employees. We have a full-time case manager, a full-time employment specialist, and a part-time data intake specialist. Our staff are constantly trained in the latest evidence-based practices to give them an advantage working with the returning citizens that's coming out of these institutions. We offer orientations, peer support groups, and job readiness workshops. When an offender comes to us, we conduct a risk assessment called the MOST, an offender screening tool, to better assist us in recognizing risk factors that led to bad behavior and decisions and possibly reincarceration. Additionally, we use case plans that allow our case managers to assist the returning citizens with identifying and accomplishing their goals. Our case managers are key to the process, as oftentimes offenders deal with multiple people while incarcerated. Once someone seeks help with Virginia Cares, they are assigned a case manager who is a one-stop shop for all of their needs. Our peer support groups are conducted using carrier guides, an evidence-based curriculum that helps change offenders' behaviors and critical skill deficit areas. We offer a variety of services, from emergency and stabilization services to transitional services and to the more intensive reentry services. Staff is very effective in building long-lasting relationships with the community stakeholders. We build partnerships with healthcare providers, probation and parole officers, law enforcement agencies, the courts, the Department of Corrections, educational facilities, places of worship, just to name a few. Last year, we provided pre-release services to 653 individuals, post-release services to 900 returning citizens, assisted 365 individuals find employment, provided housing referrals to over 1,200 people, and assisted over 500 individuals with restoration of rights, of their voting rights. Virginia Cares is one of 9 offender reentry programs here throughout the state of Virginia. Virginia Cares belongs to a coalition of offender reentry programs called PAPIS. PAPIS is an acronym for Pre- and Post-Incarceration Services. PAPIS is funded by the Virginia General Assembly through the Department of Justice Services. PAPIS consists of 9 community-based nonprofit organizations across Virginia that have been providing transition and reentry services since the early 1970s. PAPIS has 47 full-time and 22 part-time employees with almost 700 volunteers. PAPIS serves 96 jurisdictions throughout the Commonwealth, covering 94% of Virginia's populations. Virginia Cares, like PAPIS organizations, works to reduce recidivism and provide education, job training, and other support services to release individuals, an important part of the last 3 governors' enhanced emphasis on reentry initiatives. Prior to 2008, the PAPIS Coalition received $3 million annually in state appropriations. In recent years, that figure was reduced to $2.2 million, despite rising program costs and increased demand for services. However, we are grateful to the General Assembly and the governor for allocating an additional $1 million in our budget passed during the 2020 regular session. Of course, this $1 million has been unallotted, and we ask that you please reinstate those funds so reentry programs can expand and improve access, delivery, and results. particularly in the face of COVID-19, as local jurisdictions are releasing offenders in an attempt to decrease jail population. There is a need for reentry services now more than ever. Many service offenders must access in order to have a successful return to society have moved to appointment-only scheduling or are entirely online. Reentry services are an important piece to help returning citizens navigate this complex pandemic landscape, including access to essential services, thereby decreasing their chances of reoffending. Now that's my spiel coming from a professional level. I would like to talk a little bit about my personal perspective with Virginia Cares in general and PAPS as a whole. I too am a returning citizen. I was incarcerated here in the state of Virginia from 1993 to 1996. When I was incarcerated, I entered our local Virginia Cares program while incarcerated, did a lot of pre-release services with the case managers, came home to Roanoke. The program helped me find a job at Senator Edwards. You might be familiar with Validale Foods in Salem. I was working at Validale Foods from 1996 to 2000. I was constantly going back to Virginia Cares, volunteering and giving time, and just wanted to give back to my community. So in 2000, I was fortunate enough that a job at TAP, our local community action agency, came open in the Virginia Cares program, and I was hired as an intake specialist. The intake specialist is usually the coming in job to Virginia Cares. So I started as an intake specialist, quit my job at Validale, was at Virginia Cares as an intake specialist. Within a year, I was an employment specialist, going out into the community, working with all the employers in our communities, explaining Virginia Cares, what we do, how we do it, what type of clientele we work with. About a year after that, I moved up to case manager. So I was working my way up until the local TAP Virginia Cares program. I became a case manager. And lo and behold, I obviously did so good. And lo and behold, in 2007, a job came open with Virginia Cares Incorporated. And I've been the chief operations officer since then. So I am personally invested as well as professionally invested in offender reentry here in the state of Virginia. And I thank you guys so much for listening to us, being advocates to the PAPS program. With PAPS program, we cover a large portion of the state. There are still some untapped territories in Virginia where there's no services for returning citizens. We would like to expand that and open those sites up for services. But you know, I can never speak enough about Virginia Cares. I can never speak enough about PAPS and the things that they do. And again, I appreciate you guys for being advocates for reentry here lately. I've been seeing a lot of with this House right now, with this Senate right now, man, you guys have been working diligently to assist us and make sure we had all the things we need. So personally, I just want to say thank you. I appreciate it, because if it wasn't for these type programs, I'm sure I probably wouldn't be sitting here today. So with that being said, thank you, Senator.
Thank you, Anthony West. We really appreciate your presentation. What you do is so important to help people get back on their feet. It's more important than most people realize, because when people are getting out, they have a hard time getting back on their feet and getting into society. But thank you for all the work you do. And I think it's extremely important. Any questions of Anthony West? Yeah, Senator Jennifer Boysko.
Thank you, Mr. Chairman. Mr. West, thank you for being with us today and for sharing your story. And inspiring to hear that you have been incarcerated and now are leading this important organization. We are looking at some proposals to increase access for people to have a pathway to getting back out into the community. One is a compassionate release for our elderly incarcerated individuals who are perhaps sick and would like to go home to families. The other is the earned sentence credit bill. And I'm wondering from you if you could help us understand if you feel like that's a good idea, that there are supports in the community to help more individuals get the help that they need to effectively enter society.
Yeah, Mr. West?
I'm sorry.
You hear the question? Did you hear the question?
No, I really couldn't hear the question.
Okay, Jennifer, would you like to?
Okay, I'll try it again. And I would just ask if somebody's not speaking, if you'd mute your phone so we don't get any back. I think that's what was happening. So, Mr. West, what I was saying was we are going to be considering at least a couple of pieces of legislation. Could you please mute your phone, whoever is the iPhone? Thank you. So, Mr. West, we are looking at a couple of pieces of legislation, at least, that would help introduce more opportunities for people to go back out into the community by earned sentence credit, which Delegate Don Scott carried during the full session, and he and I will be working on that this session as well. That could assist people in working towards the different activities in prisons that would be education and reentry, job training, mental health kinds of things. And I'm wondering, with the PAPAS program, if you feel like we will have capacity to help guide folks and give them the supports. I'm just wondering what your thoughts are on increasing opportunities for getting people out of incarceration and into back living sustainable and positive and productive lives in our communities.
Yeah, I strongly believe that PAPAS has the infrastructure to assist more people coming out if the legislation is passed, which I hope it is, because I truly believe in people having second chances and having the opportunity to come out and get their lives straight. But I think PAPAS, we have the infrastructure in place. I mean, I know that Virginia Cares, as well as other PAPAS members, we developed so many relationships out in the community with other stakeholders and other agencies and organizations out there that, everybody's pretty much on board with making sure, for the most part, that men and women who are being released are coming through our programs to getting the services and the attention they need to go on to be successful. I think when they established the reentry councils here in the state of Virginia several years ago, I think that helped a whole lot, because that allowed everybody that was kind of like in the reentry arena to come together and work together to understand what type of services each individual agency provided, so we wouldn't be doing 2 or 3 services for one person. So I think we had the infrastructure in place, and if given the opportunity, I'm sure PAPAS could make sure that we're there every step of the way to help these men and women who is coming home. I hope that answered your question.
Yes, it did. Thank you so much.
You're welcome.
Mr. Chairman, Mr.
Senator Lucas.
Yes, Mr. Chairman, I just wanted to tell Anthony how much I appreciate all of the hard work that he's done for Virginia Cares. And I don't know if he recalls, but back in 1984, I was executive director of the STOP organization. And of course, I had oversight for the Virginia Cares program. I worked alongside people like Ted Ellick down in TAP and Rob Jones, Edith Jones, Sherman Saunders, and we all worked together for many years with the Virginia Cares program. And I just want to thank you again for all of your hard work, for all the years you've been going back and forth to the legislature, sharing the experiences and also the profiles of people who come, who've joined the program and how much they've changed their lives. And so I just can't tell you any program that I'm aware of that does more to help returning citizens than the Virginia Cares program. So I just wanted to compliment you on your work.
Thank you so much.
Mr. Chairman.
Well, yeah, Senator Serval.
Thank you, Mr. Chairman. I had 2 questions. One is a question I'm going to ask for Senator Norman, because he seems to be pretty shy today. But in asking questions, but Senator Norman had a bill that he carried last session, which would allow somebody to obtain an expungement on an offense for which they were pardoned. And we were kind enough to add some other policies to his bill to let him carry it over to the House of Delegates, where he was unceremoniously sent off to the Crime Commission. But the Senate has proposed to expand expungements, again, both for people who are pardoned and folks who have done programs for marijuana or alcohol and got those dismissed, and also for people who got certain substance abuse convictions before they were 21. And I was just curious if you could sort of comment for us on how valuable you think that might be to your efforts if we were able to expand expungement policy to some extent for the people who you have to serve every day.
Okay, Anthony?
Yeah, I thank you for the question. As a matter of fact, that would not only help others in our program, but that would help me tremendously. Here recently, I was just awarded, yeah, I was just awarded my pardon by Governor Northam last year, and I saw that legislation was trying to be passed on expungement. And I know some people that come through my program, I mean, while it's okay to have your voting rights, it's fabulous to get all that stuff back. When you go apply for jobs and stuff like that, when they still do the background checks, a crime from 20 years ago could show up and eliminate your chances of getting that job. So with the expungement, I'm all for it, and I'm sure that the people that come through our program will be all for it. That expungement will be a great help to some people that want to get jobs in certain fields, like in the healthcare field. You know, if you got any type of record, regardless of what it is, the chances of you getting a job in that field is slim to none. And, you know, I feel like once a person has been inside, paid their debt to society, did all the things they're supposed to do, while they were inside, they were role model inmates. They was doing everything they were supposed to be, getting all the degrees, getting all the education, getting everything they could. You know, once they come home, I don't think that they should be punished again. So to answer the question, I think expungement would be fabulous for the program and fabulous for the men and women, the returning citizens who are coming out.
Okay, thank you. Any other questions?
Mr. Chairman, I had one more question for him.
Mr. Sherville.
Thank you. And just, I wanted to put a little finer point on Senator Boysko's question. So the earned sentence credit bill that Delegate Scott proposed, which the Senate has also proposed, would allow people to get out of prison more quickly if they are of good behavior in prison. And at least the legislation is drafted, according to the fiscal impact statement, would result in about 6,900 people being released fairly quickly. And the fiscal impact statement on it indicates that the Department of the current probation officers' staffing models have one probation officer for every 70 people they have to supervise once they're out. And you know, I want to make sure we're clear. I mean, do you have the resources to Pappas and your group? Do you think the resources exist to handle that many more people coming out, say, in the next like 1, 2, 3 years? And what is there anything that you think we could do for you to help you facilitate that process if we were to choose to do that policy to make this all work better for everybody, to help these folks reintegrate in society if we were to pursue this policy?
Yeah, Anthony?
Senator Surveil, am I saying that right?
Yes, sir.
No.
Sir, okay, sir. I'm sure that there are more sharper minds than me within this Pappas organization that will probably give you a more definite answer than I can. But I would say with the collaborations that the Pappas organization build across the state, with our partnership, we rely a lot on the resources of our partners to do the work that we do. But I don't want to sound cliche when I say this. I really do think that we can do it. But of course, it's going to take funding and things of that nature to broaden and expand our resource base. I mean, if you look at it, we've been doing great work here in the state of Virginia for the last 20-some years. Pappas Coalition has, but I'm sure with the influx of this legislation passed, I'm sure we're going to be there every step of the way to try to make it happen, do the best we can to make it happen. But at some point, I'm sure we're going to be needing more funding and resources to expand, to make these services widely available to these people that's beginning to come out, if they come out, if that legislation passed.
Okay. Any other questions? Well, thank you, Anthony. Thank all of you for being here, Colonel Pike, Amy Ashworth, Shannon Taylor, and everybody that asked questions and weighed in on this. I think it's been very helpful. And I want to know if there's any further discussions. Okay, if not, we will go ahead and close with an adjournment, and we will be back. I'll let you keep you informed as to when we have a next meeting of the Judiciary Committee. We're going back, as you know, the 18th for God knows how long. I would like to see us have whatever bills we have ready to go and not have to wait, get them all done one day, if at all possible. So keep that in mind. Are there any other questions? Okay, if not, without any further ado, we'll adjourn the meeting. Thank you all very much.
Thank you, John.
Thank you.